Dear professors, colleagues, thank you for having me here. It's been more than 45 years from the first successful IVF procedures in England. It just coincides I am 45, I still think I'm young, but in fact 45 years is quite a period. But interestingly, we tackle the same questions once again, and many of them are not even solved in their entirety. But 1978 is not only crucial point for the legal and ethical aspects in ART. We know that contemporary legal ethics rose around Fletcher's lectures in Harvard, USA, which were dealing with ethical issues on artificial insemination. So the cradle of ethics and bioethics are in fact very much linked with reproductive medicine. And having in mind also the thoughts of Steptoe and Edwards in their monography Matter of Life in 1980, they said, IVF procedures brought hope to thousands of infertile couples, but at the same time, they triggered interest to millions of others watching from the sidelines. Who are millions of others? There are politicians, clergy, society, individuals, future parents. So those questions trigger a broad area of individuals, so they have to be taken with extreme care. These are perpetual issues that rise around reproductive techniques. Which procedures shall be offered to the couples? Who are the individuals that are entitled to IVF? Questions regarding donation and storage are always very actual. Shall we allow procedures after death? What is the status of anonymity, especially in donor programs? Surrogacy is the question which is to date. What about testing and research? Genetic testing, genetic screening, is there any difference? What about reimbursement of costs? And the topic of the status of embryo, which in fact links with many questions in ART. Surrogacy, donation, rights of an embryo perhaps? We'll see. Of course, today we do not have the time to tackle all of the topics, but let's see some of them. Regarding individuals which are entitled to the IVF, early legislations mostly offered IVF treatments only to heterosexual couples. This was the decision made in early legislations, let's say around Europe. But today there is a trend of broadening such circle, either to single women and female couples, as in Germany, Benelux, Spain and Portugal, or only to single women, as known in Hungary and Croatia. On contrary, in Austria we have made a solution that the IVF treatments with own gametes is offered only to female couples. In Slovenia, we have now the decision of the Constitutional Court from October 2024, which offers the IVF treatments to single women and female couples, but the decision is not yet implemented in the legislation. However, as my information goes, the Ministry of Health prepares the new text on the amendment on our reproduction law. Some countries also differentiate the circle of individuals regarding donation or non-donation procedures, but there is usually no broadening of such circle to male couples due to the question of surrogacy. Here we have some examples on donation procedures offered in various jurisdictions. In early regulations, there were a lot of restrictions. However, today, in many countries, the donation of both sperm and oocytes are offered. Also, in the same procedure, in certain states, both the donated sperm and oocyte can be used, such as in Benelux, Hungary, and Austria, while some other countries combine, have the possibility of use just the one cell in one procedure of IVF, and also few countries with the embryo donation, such as Germany, Spain, France, and Croatia, I believe. So we see that there is a lot of combination. However, we have to know that there are also different conditions for such procedure, differentiated by the state, and there is a rising number of countries with embryo donation. However, we see that biological relation with one of the partners is no longer a must, which was a rule in early legislation, which corresponds to embryo donation procedures and those one in which both cells are used from the donated parties. Let's move to surrogacy a bit. This is also an important topic. Predominantly there was and still is a ban on surrogacy agreements, mainly due to the three reasons: prevention from exploitation, due to the reasons of dignity of surrogate mother, this is an important pillar of the ban still, and due to the medical reasons. Very few people write or talk about medical risks arising from surrogacy, and if we explore the principle of proportionality, we see that for a surrogate mother which does not gain any medical benefit, every risk is sometimes seen as disproportionate. On the other hand, certain US states permit altruistic surrogacy, such as Ireland, Greece, Cyprus, and Portugal. In some states, legislation is not yet adopted, but there is a common understanding of permitting those procedures. The case law of European Court of Human Rights is set to recognize legal consequences of the surrogacy, especially in establishing the parenthood. This is very important. If you perform a legitimate surrogacy agreement or you execute legitimate surrogacy agreement abroad, you should not be prevented for proper legal consequences within the EU. I think this is an important approach of ECHR. But on the other hand, we see today that there is also strong initiative on universal ban on surrogacy. I just reviewed an article from the field and from this region, and there are some strong conceptions also from the doctor that there should be universal ban of surrogacy based on legal, ethical, and medical arguments. So I do not see a major developments here. However, let me address a French example of surrogacy. The French Senate opened a wide discussion which took some years on the question, and those material are really prime ones, since they tackle cultural, medical, legal, ethical aspects. And I think that the report of the Senate is about 90 pages long, and it's of course worth reading as an example of a lucid and a professional approach to the topic in one of the EU states. Let's tackle anonymity also a bit. This is a conflict with two opposite rights. On the one hand, we have a right to undisturbed family life, so that the family involved in the IVF stays in the same condition as in entering the procedure, and the right of the child to know your origin. We know that generally there is a trend towards increasing the importance of the right to know your origin. Therefore, there are certain countries that have either mixed system, so either to enter anonymous or non-anonymous regime, or either they offer non-anonymous procedure as a rule. However, on the other hand, we have still strict anonymity rule in 18 EU countries. Why I say 80 EU countries plus, this includes also the candidate states. So there is quite some difference also in this field. Regarding genetic testing and position of embryo, we have the known judgment of Costa and Pavan versus Italy from 2012. It ruled that the ban of genetic testing for a known disease is a violation of a right to family life under convention, and it established a right to bring a child into the world who is not affected by the illness that they carry. However, we have the differentiation now from here. PGD procedures, I am taking the old word, but the doctors told me that nowadays they are called PGTM or PGR-SR. This is a procedure which tackles the test for a known disease. And those tests are offered in many EU states by now. However, testing or screening for any disease is prominently still banned. So the PGS procedures or PGD1 procedure are still banned due to the ethical reasons, because they will interfere into the choice of an embryo or a future child above the level of proportionality. Let's say something about status of embryo. I'm the one who am promoting the arguments and discussion around this topic. This topic is sometimes avoided due to the many different opinions, but I think that different opinions shall be tackled and some mutual solution shall be found. We know that now we have full array in the embryo status, from full status, meaning embryo has all of the rights of a living person. On the other hand, it has no right. This is also too drastic, but I'm the one who advocates for the limited status. This means that embryo gets more rights as much as develops in the mother's womb. This is, of course, a theoretical conception, but we can start talking how to apply this to the actual rights within legal systems, especially in the healthcare. I was very shocked knowing that there is practically no individual right of a future child, embryo, fetus in healthcare, which I deem problematic. However, on the other hand, in the fields of reproductive medicine, there are a lot of provisions which go in favor of protecting of embryos. So let's promote reproductive legal solution as the one on which we can build the wider status of embryo protection in many legislations. So, to conclude, we see that similar legal ethical issues are debated since the beginnings of modern reproductive medicine. There has been some development, as we see in legislation. However, no common rules are in fact established. So I'm also the one who advocates for common EU regulation relating ART. Why? I think there is no much legal grounds for differentiating individuals based on nationality or citizenship criteria. If you are the one who wants a child, I think that there is no real reason to differentiate you, either you live in Vienna, Budapest, or Maribor, right? As it was known in UK that no postcode related rights to child should be adopted. I think that this should enable easier and equitable access to reproductive health in Europe. And of course, I think we would prevent negative impacts of reproductive tourism, which of course burdens the financial and emotional status of individuals. So, but we have to be aware that this is still an area which is vulnerable to potential abuse. So we have to observe all ethical standards followed by Oviedo Convention and other international acts, and to adopt consistently proper safeguards in the regulation to establish the solution which would be in the best interests of those millions who we have quoted initially. Thank you.